Welcome back. The Attorney General of the State of Osun has also contributed to the debate on the much talked about issue of restructuring. He spoke about these and other issues at an interactive session with journalists.
When we talk of restructuring of Nigeria, it's about whether we should ask ourselves, can we sustain 37 bureaucracy? Well, we have one for federal government and one for 36 states. So when you look at cumulatively, I don't know, I challenge whether we can get our economists to even know what is the old money that all levels of government in Nigeria are using to service bureaucracy, and whether if we downsize or we restructure ourselves into an efficient government, we will not have enough to industrialize and develop. Because when you look at when 75% of your earnings goes to servicing bureaucracy, where is the money to develop and plan for the future? So it goes beyond Rauf Aregbesola, Ajimobi, Rocha Sokorocha, this one Wai-Rufai. There are fundamental problems that we must address. So the yes, is unfortunate. Most of the people that are in the civil service are there because there is no other outlet for employment. No industries, no factory, and no production. So we need to address the issue of bringing back our economy into part of productivity. Let us have production and let us make what we call Nigeria today. We should also remember that this territory covered by Western region is now being serviced by about 8 bureaucracies now. Ogun, Oyo, Osun, Ondo, Ekiti, Edo, Delta. They were under one bureaucracy from Ibadan. They are now being serviced by 7 bureaucracy, 7 legislative houses. Until we radically restructure Nigeria along regional lines, and I believe that is the way, we will continue to run a country that will also just be at underdevelopment level, because there is no money to really galvanize development.
The Osun State Attorney General also identified the need for forensic laboratories and the promotion of alternative dispute resolution as some solutions to aid speedier dispensation of civil and criminal cases.
The bane of lack of expeditious determination of criminal cases is actually the near prostate level of our criminal investigation process. You don't have forensic laboratory by which even offenders or offenses can be properly investigated. Secondly, the accessibility to even of the IPO for the purpose of criminal prosecution is also another problem, and this accessibility is varied. One, because we have a federal police by which an officer of the Nigerian police can be moved today from Lagos to Maiduguri, from Maiduguri to Warri. So when you have a case, you already have your case file, you already issued your advice as the prosecutor, you have gotten the criminal prosecution, then the IPO get transferred. The question is, how do you bring back the IPO from the duty post? Even at times when it comes, the prisoner is not brought from detention, the case cannot go on. One of the areas is that there is a need for the Nigerian government to address the question of the police as a basis for expeditious determination of criminal cases. Because most of the time, even when cases are not properly investigated and witnesses are not on ground, there is nothing that the Attorney General of the state or the judiciary can do about it, because they are not prosecutors. They can only act on what has been done. So one of the ways by which we are doing is that we are collaborating effectively with the police in the state of Osun to ensure that we expeditiously check cases and get witnesses that are vital to appear before they get away. Then one of the ways is also that it's not all criminals that must be brought to book.
And just before we go, let's do a quick recap of the top trending stories from the courtrooms.
We begin with the report that the Federal High Court sitting in Abuja has assigned to Justice Abdulkadir Abdulkafarati a suit seeking an order to compel the Senate President Dr. Bukola Saraki to appoint a medical panel to determine the health status of President Muhammadu Buhari. The suit was filed by a United States of America-based Nigerian, Mr. Toyin Daudu. President Buhari had left the country for the United Kingdom since May 7 for a medical vacation. The case is, however, likely to be heard after the annual court vacation, which commenced earlier this month. Judges of the court had on July 10 proceeded on their annual vacation, with only few of them assigned as vacation judges to hear very urgent cases during the period. The judges are to resume in September. In Lagos, the Federal High Court has granted an interim order for 7 commercial banks in the country to remit a total of $793.2 million allegedly hidden with them in violation of the Constitution and the Treasury single account policy of the federal government. Presiding Justice Chuka Obiozo ordered the 7 banks to remit to the designated CBN Asset Recovery Dollars account various amounts allegedly kept in their custody illegally. The court made the interim order after listening to an ex parte application filed by counsel to the Attorney General of the Federation, Professor Yemi Akinsanya George. While arguing the application, Professor Akinsanya George said that the withheld funds are urgently required by the federal government for executing the 2017 budget. After listening to him, Justice Obiozo granted the interim orders. He then adjourned till August 8, 2017 for anyone interested in the funds to appear before him to show cause why the interim orders should not be made permanent. The same Federal High Court in Lagos has also granted an order of interim forfeiture of a property at Banana Island area of Lagos said to be owned by a former Minister of Petroleum Resources, Mrs. Diezani Alison Madueke. Besides the property, the court also ordered the temporary forfeiture of the sum of over $2.7 million and over 84 million naira said to be part of the rents collected on the property. The court made the forfeiture order after listening to an ex parte application brought by the head of legal of the Economic and Financial Crimes Commission, Mr. Anselm Ozioko. The ex parte application was filed pursuant to Section 17 of the Advanced Free Fraud and Other Related Offences Act No. 14, 2006 and Section 44, subsection 2, paragraph K of the Constitution. Apart from Mrs. Alison Madueke, a legal practitioner, Afamifuna Nwokedi, who allegedly acted with the former minister and the company, Rusim Pex Limited, were also listed as respondents in the application. The court has directed that the interim order should be published in a national newspaper so that any interested party who does not want the property and money to be permanently forfeited to the federal government could appear in court before him. Further proceedings has been fixed for the 7th of August. The Court of Appeal, also sitting in Lagos, has upheld the conviction and sentence of 9 foreigners for stealing 3,423.097 metric tons of crude oil from Nigeria. Justice Frederick Oho, who read the judgment, held that the appeal of the foreigners lacked merit. He subsequently dismissed it. The Federal High Court Lagos had convicted the foreigners, 5 Filipinos and 4 Bangladeshi nationals, to a jail term of 5 years each on the 4-count charges against them, with an option of a 5 million naira for each count. The vessel, MT Asteris, and its crew were intercepted by the Nigerian Navy ship Beecroft during a routine patrol in Lagos in March 2015 while trying to export the stolen product. Upon interrogation, the captain and any of the crew members could not produce any relevant document authorizing the lifting and destination of the petroleum products they had on board. In handing down the sentence, Justice Bubo said he was satisfied that the EFCC proved its case beyond reasonable doubt. And we round off with the news that a former minister of the Federal Capital Territory, Olajumoke Akinjide, who was charged with an alleged fraud of 650 million naira by the Economic and Financial Crimes Commission, has urged the Federal High Court sitting in Lagos to allow her travel abroad for medical treatment. The former minister brought the application before the court through her counsel, Balaji Ayorinde. The judge, however, could not hear the matter as it was not listed for hearing. Justice Obiozo subsequently adjourned till July 26 for the lawyer to come and argue the application.
And that's the program this week. You can watch it again on our YouTube channel. Kindly give us feedback via any of our social media handles. I'm Shola Shoyeli. Thank you for watching.